Good morning, and thank you so much for joining me for what is undoubtedly going to be both an informative and very, um, perhaps emotionally charged seminar today. We're going to be talking about divorce in general and the pandemic's effect on it. For those of you who haven't heard me speak before or don't know me, by way of introduction, my name is Monique Madan, and I am a certified financial planning professional, a financial management advisor, and a chartered financial divorce specialist. And that really is the accreditation that I bring to this webinar today. Now, my background is a bit unique in that my undergraduate education is actually in neuropsychopharmacology, which is a fancy way of saying the drugs effect on the brain. And then I only turned to personal finance kind of in my early career years. Now, since then, I have worked with, a gamut of different clients from high net worth individuals to the very vulnerable, and as you can imagine, every conceivable situation in between. When people ask me, Monique, describe the type of client who would best benefit from working with you, I typically would say people who are facing difficult decisions, this topic being, amongst the most important, but those who are facing difficult decisions who maybe have to decide between competing objectives, I would say they're the ones who receive the most value from our work. And certainly both the topic at hand and the current state of our economy means that more and more Canadians are finding themselves in those kind of tough decisions. With respect to how I do my work, I am the head of financial life strategies at UPotential and at ETF Capital Management. Just so you understand the link between those two, UPotential is the fee-for-service arm of an umbrella organization called Quintessence Wealth. As a fee-for-service planner, basically what I do is I provide unbiased advice and strategies on a fee-for-service basis through UPotential. What fee-for-service means is that I don't have a license to sell any products. I don't sell stocks, mutual funds, insurance, nothing of that nature. And then further understanding the connection between myself and ETF Capital Management. ETF Capital Management is the largest partner firm of Quintessence Wealth, and the principal is Larry Berman, whom you may have heard. And thankfully, Larry has enlisted my services for his clients as part of the suite of services that they receive. So you can access my services if you are a client of ETF Capital Management, at no cost, or by way of a fee-for-service option through UPotential. One bit of reassurance I just want to give to those clients who are coming on the UPotential side, we have created very deliberately an ethical wall between the two firms so that whether you're coming from a fee-for-service side or a client of ETF Capital Management, you will receive the same unbiased strategy. And on the ETF Capital Management side, of course, that's coupled with best-in-class investment advisory services. Focusing on the topic at hand, although not everyone will face a divorce in their lifetimes, it is prevalent enough that it's worth some study. So as I mentioned at the beginning, some years ago, I embarked on a specialized degree in divorce planning. Initially, the accreditation was from the United States, and it was a Canadian version of the US study. And then I found one with a more Canadian focus. So those of you who are facing the prospect of a separation or divorce, or know and care about someone who is, I'm really incredibly grateful for our time together today. Now, why is it so important that we're discussing this today? Well, despite the fact that the world is in the midst of such unbelievable upheaval, the truth is that the COVID pandemic has forced us to have some very serious contemplation of health concerns, but also on, a more philosophical note, people are kind of across the board reflecting on their lives and making some decisions on how they may want to change their lives. And that has basically meant more people considering whether their life choice was the correct one. The pandemic has also placed, I think we can universally agree, unprecedented physical, psychological, economic stress really on every part of society. It also has changed the meaning in many of our lives of family time. You know, COVID-19 has redefined parents as teachers and spouses as entertainment, and all at the same time while we're still responsible for our own workloads and our own economic responsibilities. In my own case, I'm not afraid to tell you that, I have a serious case of what I call baloney syndrome, where I'm sandwiched between the needs of my children, who are 15 and 19, and caregiving for an elderly parent who is declining with whether it's dementia or Alzheimer's, no one knows just yet. And lastly, and unsurprisingly, the pandemic has put us in a situation where isolation is to our benefit, but at the same time, many people and many studies have shown a higher incidence of spousal violence resulting from the fact that couples are spending more time together and further away from their support systems. So combined, these pressures have really meant that relationships that had already been tested and tried and maybe have showing some cracks or pre-existing conditions might in fact dissolve. Interestingly, prior to the pandemic, surveys had been reporting increased marital satisfaction, oddly enough, in a material way. But now anecdotal evidence that I found from the publishers of a company called Legal Templates, and this is a website dedicated to providing boilerplated type of legal documents. They've noticed a 34% increase in the sales of divorce agreements. So whether people are actually meeting with lawyers and proceeding or not, there does seem to be a shift in the focus away from what had been a nice reprieve from marital dissatisfaction. Now, there are really three primary considerations through the separation and divorce process. One is certainly financial. Arguably more importantly is the legal aspect. And finally, for those with dependents, there is the family aspect, the ongoing access to children and their rearing, decisions around their rearing. Now, this is as good a time as any to make mention of the fact that as a financial specialist, I'm prohibited from providing legal advice. So I'm going to be focusing my commentary specifically on the financial aspects of separation and divorce. One material definition that you should be aware of is that separation is different from divorce. Separation refers to the process where, let's say, one household becomes two, both physically and emotionally and financially. Both married and common law spouses can separate, but divorce only refers to the legal division of assets of a legal marriage and the decree by which, spouses may or may not have continued obligations to one another. This distinction becomes important for us. For example, common law spouses can't divorce, and they also do not have rights to each other's property. On the other hand, married spouses could decide to remain separated indefinitely, some for religious reasons and some for other reasons. Throughout our discussion, I'm going to use those terms fairly interchangeably, but do appreciate that there is a legal distinction between them. Naturally, when you think of separation or divorce, your first objective is likely, and rightly, by the way, to engage a lawyer. But it's not going to take long before the financial aspects of divorce are going to become apparent. Specifically, three financial aspects that we'll be focusing on and will be the focus of your negotiations are division of property, the financial support of children, and the goal of moving towards a time when the spouses will be financially independent of one another. It shouldn't come as a surprise to many of you that divorce is regularly reported as maybe the second most stressful life event after perhaps the death of a loved one. It's tremendously personal. And in the case of divorce in particular, it involves legal rights, obligations that may linger, well after the physical separation of the spouses. It's also intended to be permanent. So consideration must be given both to short-term decisions as well as the long-term ramifications of those decisions. And this is what requires enlisting the expensive professionals, specifically lawyers, whose advice does not come cheaply. We'll discuss later how you can work towards a process that is relatively peaceful, but also one where you can control to some degree the costs involved in separating your lives. In some divorce negotiations, clients come to me to have, let's say, that extra professional in their corner. However, I'm often engaged also by both spouses in order to help their lawyers balance the critical needs of today and the long-term prospects of both households. This typically allows lawyers to make sure that the agreement that they're crafting doesn't unfairly burden one spouse or unfairly enrich the other. And this becomes incredibly important because research has shown that the divorce itself may not affect the psychological development of children, but what could affect their welfare over the long term is when they see one parent living in poverty. So the idea of creating a long-term outcome that is beneficial to both parties really does affect the children in many cases. Now, what do I do in these engagements? Typically, it's, like I said, financial in nature. I collect and present financial data in a way that the lawyers and the courts can use. I do projections on various proposed divisions of property and support obligations where I show both the immediate effect, can the two spouses create two separate households and afford their costs of living, but also projecting in that long term. Will the spouses, in some cases, this isn't the goal of every divorce settlement, but in some cases, will one develop wealth, well beyond many multiples of the other? This doesn't come into every situation, but it does come into the situation of some of the longer term marriages out there. And then again, focusing on helping both parties reestablish themselves financially after the divorce. It's interesting to note, by the way, in cases where I'm engaged by both parties, after the divorce or separation is signed off and completed, I cannot work with those clients any longer. I have to refer them elsewhere. So my objective today is to dispel some myths about separation and divorce, to talk about what you might want to do to prepare for your first meeting with a lawyer, and 3 tips that might help you save some money through the divorce and separation process. So let's start with some myths about separation and divorce. I'm sure many of you have seen situations, whether it's sensationalized on TV or in other, maybe amongst friends and family, where someone says, that's it, I'm going to take this guy to the cleaners. If you haven't already thought about this, I'll bet you the people who love you have. And this attitude simply isn't constructive. The type of revenge-seeking mentality that this exemplifies can manifest when negotiating the division of property or in support orders. Now, the overarching goal of separation and divorce in Canada is the financial independence of the parties within a reasonable period of time. By reasonable period, that's pretty, there's a fairly wide range to that. What I would have you think of is reasonable period is typically influenced by the ages of the children or the time it might take one of the two spouses, if applicable, to retrain or re-enter the workplace. So if there's a situation where one spouse has, let's say, skills that that aren't in demand any longer, and the courts want that person to be financially independent at some point, the support order may last long enough for that person to go back to school and retrain and come up to speed. Specifically with support orders, most are time limited, allowing time again for one spouse perhaps to ramp up his or her earnings. And it's only in the most traditional of marriages, let's say where one spouse sacrificed his or her career to stay at home, and especially in lengthy marriages where someone has, where both spouses really have come to rely upon one another to create a standard of living for the household. Those are the situations in which decrees may be termed indefinite, which really just means there's no specific time where the divorce decree would be, or the support order would be reevaluated. Another idea might be that, you're so angry with what a spouse did, that lying, cheating SOB is going to pay for what he's done or she's done. Well, the truth is in Canada, we have, much like our car insurance, we have a no-fault divorce system, meaning that the courts simply don't care what brought you to this point, what made you want to dissolve this relationship. So if you think you're going to go to court and win favor of the judge, surely the judge is going to side with the blankety blank. The truth is that fewer than 3% of these files actually go to court, and specifically to trial. Many of them go to court for motions, but not for trial. And even those that are positioned for trial, many of those end up settling out of court. And what I can tell you anecdotally through working with many, many family lawyers is that they're well aware that even the strongest of cases can be decided against you. So there's really no constructive way for you to think that you know or could predict what a judge would decide. Perhaps the most sensational myth of all is the idea that one spouse is hiding money or is not reporting what they earn accurately for taxes. What you should know is that first and foremost, courts do require full disclosure, and failure to disclose financial or any sort of requested information is subject to legal consequences. That being said, if there's a legitimate reason, let's take into consideration that most accusations of hidden assets are fiction. But if you have a reasonable concern about this, there are professionals, they're called forensic accountants, and they can help you trace assets in an effort to support full disclosure. Now, as we'll soon discuss, there are alternate ways of proceeding with a separation or divorce. And this becomes important with the idea of disclosure of income and assets, because to put it mildly, there are some delicate matters that might attract the attention of the Canada Revenue Agency that would best be dealt with perhaps out of court, because divorce proceedings can become a matter of public record. So many will opt for what are called alternative dispute resolution forums. You might have heard of mediation or collaborative practice. Many people will opt for these ADRs, alternative dispute resolution forums, because of a need to keep things private. And lastly, if it's not uncommon, particularly with people who own their own businesses or have a largely cash income, to not report their income accurately for taxes. And I'm not going to say that that's appropriate. I'm just saying that it is a fact. But I want you to be aware that courts are accustomed to this. They've seen this 6 ways to Sunday, and they can do something called imputing income, where they will gather information from various sources and come up with an income that they will use for the purposes of whether it's child support or spousal support that may not relate to a tax return. So just be reassured that in those cases, most courts will see through that and be able to more accurately portray the payor's income. So let's move on to some preparations for your first meeting with your lawyer. As I mentioned before, you're going to want to decide whether you're going to go to, a traditional, which is more like an adversarial type of a divorce proceeding, or you may want to have more control over the outcome. So I want you to ask yourself, do you want to have a say in the terms of your separation, or do you want a stranger, in other words, a judge, to dictate your future? If you want to have more input into the process, you may want to consider what are called alternative dispute resolution options, like mediation and arbitration, which is the court's way of decentralizing the process so that it can be conducted outside of a courtroom. You should know family law doesn't usually take, front stage in the courts. I was just in jury duty for a very lengthy period of time, and I can tell you that the primary work of the court system is not related to family law. And if you wanted to go to trial, for instance, you might even wait up to 2 years to get a trial date. So imagine this is someone you want to separate from, but you're going to be in limbo. You're not connected, you're not disconnected for a very, very lengthy period of time. That's not attractive. So whereas the traditional adversarial position is, 2 spouses, 2 lawyers exchanging letters back and forth and whatnot, a mediation is where someone who's trained, very often a lawyer, but not always, is trained to work out the terms of the divorce decree or the separation agreement, to draft it, and then each of the spouses would take that decree that has been worked on together and take it to independent counsel just to make sure that they're not signing away their rights to anything important. The third option is collaborative practice, and this is more of a team-based approach and is appropriate for most divorces, with the exception potentially of those with histories of violence or a significant power imbalance. The most important thing to remember when you're deciding what type of divorce to proceed with is that if you end up in court, you've already lost. So as you prepare for your meeting with your lawyer, you're going to gather up your paperwork. And in the absence of a cohabitation agreement, which would happen before you share a space, whether you're going to be legally married or not, the cohabitation agreement might dictate how assets might be divided in the future. So in the absence of a cohabitation agreement, the assets that you bring into a marriage are credited to you in the calculations. Then the assets that are accumulated in the marriage are the ones that are subject to division and what's called equalization. So to optimize the time with your lawyer, you want to make a list of the assets that you had when you entered the marriage. And again, if you have a cohabitation agreement, that's likely a good part of that document. The next more important decision is to decide on the date of separation, because that is when the value of your assets is essentially frozen in time. And that's the date of valuation that you want to get. So you want to accumulate statements and things like that that have a valuation of your assets as of that particular date. Some assets will require a current valuation, and that includes all of the current assets. So for example, if you have a home, you might need to have a realtor valuate that home. If you have a pension, you might need, in some cases, an actuarial valuation of the pension asset. But what you want essentially is 2 distinct valuations, one as of the date that you cohabitated or came together, and one as of the date of separation, because the difference between those 2 valuations is what would be divided or equalized. Tax returns become incredibly valuable because it tells the lawyers and other professionals so much information. It tells them about what's happening currently. Is one spouse the employee of the other spouse in a family business? Are there investments producing investment income? Are there loans that are deductible? All sorts of very valuable information. And as you're gathering your paperwork, it's not uncommon for one spouse to be actively involved in the finance of the family and one spouse to maybe take a lesser role. This is the time to take the time and accumulate everything that you're going to need, especially if you're going to make best use of your lawyer's time. Now, I do want to talk about something that's a little bit delicate, and that is if you are the plaintiff, the person who has initiated the separation or divorce proceedings, chances are you have an upper hand, if only because you've been giving this some thought. Okay? If you are the respondent, let's say the person not always blindsided, but sometimes blindsided when their spouse says that they want to divorce or separate, that person may need some time to catch up and digest the dissolution of the marriage. Now, if you're the plaintiff, you can expect that shortly after you ask for the separation or divorce, there may be some hard feelings. And these feelings can very quickly descend to vindictive actions. For example, if you rely upon joint assets, so a joint bank account, a joint credit card, to cover the costs of a mortgage or groceries, it very quickly, if this person, the other spouse, is not getting the right supports, could very quickly, you could very quickly be cut off. Those joint assets could be frozen or depleted. And that could make it incredibly difficult for you to get even the most basic of necessities. So it's important that if you're the plaintiff and you have some forethought into the fact that this may happen, you should go about establishing your own credit rating so that you have a cash flow source in case your joint assets get frozen. Now, if you're a lower income earner and you're worried that you might not be credit worthy, it might behoove you to establish a line of credit or a credit card before you request the separation or divorce if you're worried that you might be ineligible based on your own income. You should also open a bank account with a small sum. Now, I want to be very clear here. I am not suggesting, and I will never participate in a situation where one spouse tries to wipe out the joint savings. I'm not suggesting that. I'm just suggesting that you make sure that you have a bank account of your own with a small emergency reserve. If things descend into anger, you should have access to some money or a credit card so that you can get out of a volatile situation and continue to provide yourself with basic necessities. Along those same lines, if you're going about getting a credit card or a bank account, make sure to change your PIN numbers so that you can prevent loss. So now let's move towards a couple of tips to save you money through the process. I said before, separation and divorce is very, very pricey. And part of that is because the first person you need to engage is a lawyer, and lawyers are expensive. They have lots of liability insurance, they have costs, and they can be very expensive. So let's try to put things into perspective of what you can control. What you can control is your own attitude. First and foremost, the emotion of a divorce can quickly lead to resentment. And this especially happens when divorcing parties are beginning new families with a new partner, for instance. Let me be very clear in my impartiality of one particular notion, and that is having children means supporting them and sharing your wealth with them. Child support is not a burden. It's based solely on the payer's earnings, so if you earn it, you got to share it. Now remember, you would have shared it if those children were living with you anyway, okay? The only thing that you can look up for yourself is federal child support tables, and I will include a link in the active version of this online as it is being recorded. So that you can't really predict what spousal support payments might be, but you can predict what child support might be. Secondly, very carefully consider your housing options. You know, the matrimonial home is very often your most valuable asset, but it's also one that parents will often wish to hold on to because, you know, it's tied to nostalgia, it's tied to a particular school district, it's tied to home pride, all sorts of reasons, but they often hold on to it well beyond the point of affordability. So what I would say is if you want to keep your home because you want to keep your children in a particular school district, consider a situation where you divide all of the other assets immediately, but then make a commitment for a predetermined future date, such as, you know, when all of your children age out of that school district, and then you've predetermined when you're going to split the family home. So this will allow you to plan ahead, move your children, you know, advise them that they'll be moving from middle or high school. And this is often helpful because, you know, children in middle school or high school are more mature and they can keep relationships that are good for their mental health, even if they're not in the same class with their favorite classmates. It's also an opportunity for the spouse who doesn't occupy the home that you're deliberately trying to hold to move into an area with a desirable middle or high school so that you're planning both for the child's needs today vis-a-vis their education and in the future. One thing that's interesting is if the pandemic has taught us one thing, it's that it's broadened our previously conceived notions about working from home. So if you're amongst, you know, the lucky people who can work from home in an industry that has adapted to working from home, you can in fact work some distance away and avoid paying a premium for living close to, let's say, public transit or a city center. Now, many people will say, but, you know, Monique, I don't want the children to have to commute a long distance to visit me. But remember that those commutes can often offer a more spacious home in a suburb, right? So the family home can have detriments like, you know, higher costs, higher property taxes. And if it takes up too much of your income, you may need to discuss this particular piece with a financial professional like myself to determine if it's really worth digging your heels into keeping this matrimonial home. I also want to make you aware that your own behavior can affect the costs of the proceedings. Inefficient use of professionals' time means higher fees and a lower process. So if you're bitter and revenge seeking, I want you to try to control the way in which you communicate with either your lawyer or your ex-spouse. And I'm going to show you later on that there's some pretty interesting technology that's come to help us in this particular way. And finally, if you take nothing from this seminar but the following, I'll think that we were successful. The focus of any divorce in Canada or separation in Canada is really the amicable decoupling and financial independence of both spouses, while at the same time fostering the well-being of children. So because the process of separation and divorce is emotionally charged, it's very common for clients to dissolve into tears. So it's perfectly normal. But gossip, revenge seeking, as I mentioned earlier, those are different. Your lawyer charges you by the hour. He or she is not your best girlfriend. So you'd be well advised to avoid the temptation of picking up the phone every time the, you know, compulsion strikes. Instead, pool your questions and make an appointment with your lawyer so that you have an agenda of items that you want to talk about. This can make your phone calls with your lawyers both more productive and less expensive. Now, if you're using an experienced lawyer, he or she is very well acquainted with both the process of the courts and the attitudes of the courts. Please listen to them before you dig your heels in on an issue. Arguing endlessly, not only about the matrimonial home, but more importantly, about smaller personal items rather than items that are of financial value, those can only lead to a slower process and higher fees. So please think about taking the matters to court only if you want to have less influence on the outcome. It's possible that you could, establish a separation or divorce and deal with 90% of the assets, signed, sealed, and delivered, and then decide that you're going to take only one or two matters before an impartial mediator, arbitrator, whatever the case may be. And that too would very, very, very much reduce the costs of the process. When trying to determine whether to stand your ground, whether with regards to keeping a home or a pension or an RSP, please keep in mind that some assets have maintenance costs, like a home or cottage, and others could have a future tax consequence, like, again, a cottage or investments or pension plans. This is another really important reason why you might want to use a financial neutral, because that person can help you understand whether it really is in your best interest to fight for an asset. When it comes to using your team, the goal should not be, the obliteration of your ex-spouse. Most divorces end in, you can hope it's going to end in an acceptable agreement. If you keep your eyes on the prize, which is leading a happy, independent life with good relationships with your children, really an acceptable agreement is all you can hope for. Remember, fair is not the goal of most divorce proceedings. It's an acceptable resolution, meaning that both spouses come out kind of battered, but also with an agreement, hopefully, that they can live with. Everyone knows the traditional adversarial model where two lawyers are battling it out. It's really been considered a zero-sum predicament. One spouse wins, one spouse loses, and in a much more civilized divorce, what you really want to come out with is a compromise. So specifically, when it comes to one type of alternative dispute resolution that I mentioned, the option of collaborative practice, let me tell you how this works. This employs a team approach consisting of two spouses, two lawyers, a financial neutral, and a family neutral, a social worker, or someone whose focus is on rebuilding the emotional needs of the family. It consists of an expressed written commitment that this will not go to court. In fact, if the process dissolves and the parties do end up needing to go to court, all the members of the team have to recuse themselves and the spouses have to start all over again. This very, very heavy burden is often what helps the team get through impasses, the fact that court is not an option. So the team approach, if you're thinking about it, two lawyers, a financial neutral, a social worker, it sounds expensive on the surface. But keep in mind that what it does is it ensures that each issue is dealt with by the expert in that issue. If you're referred to the family professional for, the parenting plan or how to proceed independently and see one another at family gatherings, that's going to be done offline. That's going to be done by the social worker with the spouses independently and very likely at a much lower hourly rate than the lawyers. What collaborative practice does, it has a goals-based approach. There's an agenda for every discussion. There are objectives. We're going to get through this particular issue today, and the rest of the work is done offline with the family or financial neutral. So it, in fact, can be faster and less expensive, if you can imagine, both from an emotional point of view and financially. So I would encourage all but the most vulnerable to go through a collaborative process. As I mentioned, each meeting has an agenda. The neutrals have done things offline to work out issues, and the cost of those neutrals, so my cost or the cost of the social worker, is shared by the spouses. And like I said, usually at a much less expensive hourly rate than a lawyer. The most important note when it comes to collaborative teams is that they're not restricted to the rules of precedence. They're free to come up with any solution that meets the family's needs, as long as it doesn't infringe upon the legal rights of one of the spouses. They're also useful in keeping everyone on track towards the goal. If your goal is the amicable decoupling and financial independence and fostering the well-being of the children, imagine an emotionally charged situation where a social worker says, wait a minute, I need 5 minutes with one of the clients to help them, bring themselves back to centered and feel better about the process. It's so powerful. And most importantly, the couple's directly engaged in the formulation of the agreement rather than having their fate decided by a stranger. The only time I think where this isn't appropriate again is where there has been family violence or perhaps a serious imbalance in power between the spouses. So lastly, let's spend some time, if you're in the latter stages of a separation or divorce, let's look at how to rebuild your life, your family 2.0, in the wake of the division of property and the establishment of child or spousal obligations. You simply cannot create two households from one without incurring additional costs of living. This is especially true in large urban areas. So as we discussed previously, the pandemic perhaps has had one silver lining, if only one, in that it's introduced the possibility of working remotely, which allows people to work further from, let's say, a city center where perhaps costs of living might be less expensive. And this can also, as I mentioned earlier, have its own advantages, potentially, offering people the space or the decongested air quality of a suburb or, a more rural setting. Without question, the most resented part of separation and divorce processes is spousal support. In my opinion, anything that could make that even the slightest bit more tolerable can help, at least try to keep a more civil relationship between the spouses. So since spousal support is deductible to the person who pays it, he or she often enjoys a sizable tax refund at the end of the year, but they may struggle through the whole year to afford those payments because the commitment on a month-to-month basis can be so significant. This can be really hard, especially for someone who's trying to provide for their own needs, reestablish themselves, and potentially has maybe even a second family. So I'd like to inform you of a particularly powerful strategy, which is the filing of a T1213. And this form advises your payroll department of these tax deductible obligations. If you've heard me before, you might have heard me talk about it in relation to a commitment for RSP contributions. It's the same form. Filing this form with the payroll department allows them to recalculate your tax obligations based on a different taxable income level. And what this does is it gives you the tax refund with every pay. It increases your take-home pay. And this leaves you with more money in your account to pay the spousal support and cover your other costs of living. Very importantly, though, this is only for spousal support. Child support is not tax deductible. Let's look at an example. So if Ray, for instance, lives in Alberta and he earns $120,000 per year, and his divorce decree obligates him to pay $2,500 per month or $30,000 per year in spousal support for 5 years. Okay, so in the standard example, which is the second column, Ray earns, let's say, $120,000 a year is $10,000 per month. His monthly payroll obligations, if he does nothing, are $28.24 per month, meaning that his take-home pay, what is automatically deposited into his bank account, is $7,176. Then he's obligated to pay his ex-spouse $2,500. He's left with $46.76 for his own needs. Let's take an example where Ray has filed the T1213 form. He earns the same amount, $10,000 per month, but his payroll deductions, rather than being based on $120,000 in earnings, it's based on $120,000 less $30,000 in spousal support, which is tax deductible to him. So his payroll department only deducts enough for someone earning $90,000 a year, which is $1,957 a month. His take-home pay then becomes $8,043 with the same obligation for $2,500 spousal support, netting him $5,543. So if you imagine, he owes the same amount for spousal support, he owes the same amount for taxes. What is different is that there's an extra $867 deposited into Ray's bank account instead of a large tax refund at the end of the year. And this will, I hope, in some cases, make it a little bit more tolerable for the paying spouse to be able to afford both their obligations to their ex-spouse and, let's say, their own costs of living or the costs of living of a second family. Now, there's no question that a relationship needs to be mourned, but a separation or divorce is also a new beginning. With the right supports and, I'll be fair, a lot of work, this new family unit could conceivably be stronger than the one that had dissolved into conflict. So if the separating or divorcing parents can maintain a dialogue with respect to visitation or those extras in life, the so-called Section 7 expenses, they can continue to have influence on their children. Section 7 expenses are things like tutoring, sports, summer camps, things that are, provide extra benefit for children. Now, when Section 7 expenses are determined, they're typically pooled between the spouses, and each spouse pays a prorated amount based on their relative income. So if you both earn the same, it might be a 50-50 split. If one earns much more than the other, it might be a different percentage. But it means that both spouses continue to have a voice in how the children are raised. Now, one thing that clients have taught me is that it's really easy to overindulge children because you feel guilty about the divorce. But kids are resilient, and they can and often do thrive in a two-household family. What research has shown, on the other hand, is that one of the key risk factors for children's long-term mental health is seeing one parent struggle in poverty. This is yet another reason why a financial neutral can be so helpful. It may not be equal or fair, but the goal is to ensure that the children have two safe, pleasant, and loving homes to visit when they spend time with each of their parents. And if that burden of spousal support, because I, again, don't believe that child support is a burden, if spousal support is a burden to you, just keep in mind, please, nothing is forever. Support agreements usually include a schedule where the support amounts will be reviewed. Sometimes it's annually. That's specifically if one spouse has very variable income, or in order to report those Section 7 expenses and have spouses exchange funds. But even it can be caused, let's say, by a material difference in your circumstances, an unforeseen job loss or retirement. That can affect your spousal support decrees, even those that are deemed indefinite. Indefinite just means that there's no scheduled review, but either party can initiate a review of the support agreement. But because there's going to be legal costs involved, you would be encouraged to only initiate this if there's a fairly material difference or reason to do so. And finally, the separation agreement or divorce is going to dictate, in some cases, that you maintain your spouse as the beneficiary of, let's say, a particular account or a life insurance policy. That's a particularly common one. So you have to comply with these decrees. Beyond this, you are free to name whoever you want as the executor or beneficiary of an account or of your will, whatever the case may be. Do not underestimate how powerful the changing of these beneficiary statuses, the ones that you're allowed to do, can be, because it really does go a long way towards redefining the relationship with the ex-spouse and allowing you to move forward. So I've included some resources for you, and all of these will be live when it's uploaded onto the website. The Department of Justice is where you can find a lot of information, including those federal child support tables that I shared with you earlier. If you're at all interested in collaborative practice, the Ontario Association of Collaborative Professionals lists all the local chapters in Ontario. I happen to be a member of the York Collaborative Practice Group, but I can work with other groups. For those of you in other provinces, there is a Collaborative Professionals of Canada website where you can find local practitioners. The one that I'm most excited to share with you is an app called Our Family Wizard, and this is really amazing. It's an app that helps parents schedule, track the schedules to make sure that there's fairness and evenness according to the visitation decree. It helps them track those Section 7 expenses, those extras I mentioned. But really interestingly, it helps you maintain civil discourse between the spouses. What I've just learned is that just about any type of communication can be brought into court. Texts, social media, anything. So what I understand, and I haven't used it myself, but what I understand Our Family Wizard can do is it can, let's say, make you pause before you send an inflammatory text, or prompts you to rethink what you might be sending in an email. That is incredible. It goes a long way towards encouraging that kind of civil discourse, knowing that the meanness or the venom isn't going to get you anywhere anyway. And lastly, the Separation and Divorce Readiness Indicator is a very interesting survey of, I think it's 25 or 26 different topics that will allow you to understand how complicated is this divorce going to be based on my particular circumstances. And when spouses do this, let's say ahead of meeting with their lawyers, they can often understand whether this particular file or motion would be best achieved through an adversarial process, or could be done through one of the less expensive and quicker alternative dispute resolution methods that I mentioned earlier. The next webinar, which I'd love for you to join me on, is going to be one where we're really going to say good riddance to 2020. I'm sure you share my sentiments on that. It's going to be on January 19th, where we're going to talk about practical ways that you can set yourself up for success in 2021. Please share this well beyond the divorce community, because this is going to be a purely personal finance webinar, and I do hope that you'll join me on January 19th at 10 a.m. Eastern. And finally, I understand how very personal this discussion can be and already has been. So rather than taking questions today, here's my contact information, and I would encourage you to send me an email with your question instead. To all who've attended, thank you so much for your time and attention. A recorded version is going to be available on the website soon, as will the invitation to register for next month's webinar. And naturally, please, if I can be of any service, do not hesitate to contact me. It really would be my pleasure to help in any way that I can. Thank you so much.